Good afternoon. Thank you for joining us today. We are going to get started in just a moment. We're letting a few more people in from the waiting room. Good afternoon. If you're just joining us, we're going to give one more minute to let folks in, and then we will get started. Glad to see so many folks here today. All right, we will go ahead and get started. Good afternoon, everyone. Thank you so much for joining us. My name is Connor Cook. I serve as the Assistant Director of Alumni Engagement at Duke Law School. We are so grateful to have so many of our alumni and friends here to join us today for today's presentation with Professor Brandon Garrett. Before we get started on today's presentation, just a few small housekeeping items. Please do make sure that your microphone is muted during the presentation. We will have an opportunity for Q&A at the end of the program. So if you can just hold your questions until that point, that would be great. If you experience any connectivity issues, we recommend turning off your video. That often helps. If you have any additional problems throughout the presentation, you can feel free to reach out to a member of our team. We will put our office email address in the chat. And just to note that today's program is being recorded. We will share a copy of the recording following the program in the coming days. And I am so grateful to have the opportunity to introduce our speaker today, Professor Brandon Garrett. Brandon Garrett is a leading scholar of criminal justice outcomes, evidence, and constitutional rights. He is the inaugural L. Neal Williams Jr. Professor of Law and Director of the Wilson Center for Science and Justice at Duke Law School. The Wilson Center for Science and Justice is an initiative that brings together faculty and students to improve criminal justice outcomes. Professor Garrett's current research and teaching interests focus on evidence, forensic science, constitutional rights, habeas corpus, corporate crime, and criminal law. In addition to numerous articles published in leading law reviews and scientific journals, Professor Garrett's work has been widely cited by courts, including the U.S. Supreme Court, lower federal courts, state Supreme Courts, and courts in other countries. Professor Garrett also frequently speaks about criminal justice matters before legislative and policymaking bodies, groups of practicing lawyers, law enforcement, and to local and national media. He has been involved with a number of law and science reform initiatives, including the American Law Institute's Project on Policing, for which he serves as associate reporter, and a National Academy of Sciences committee concerning eyewitness evidence. Professor Garrett received his BA from Yale University. He received his JD from Columbia Law School, where he was an articles editor of the Columbia Law Review and a Kent Scholar. Before joining Duke Law in 2018, Professor Garrett was the White Burkett Miller Professor of Law and Public Affairs and Justice Thurgood Marshall Distinguished Professor of Law at the University of Virginia. In 2015, he was a visiting fellow at All Souls College, Oxford University. And without further ado, I will turn it over to Professor Garrett.
Great, thank you. Well, it's great to be with you all today. It's a treat to have a chance to give you a tour of my new book, Autopsy of a Crime Lab. I was able to share the book with students at an in-person event yesterday and realized afterwards that it's the first time I had talked to anyone in person about the book. I did have a chance to speak to a number of our wonderful alums about this project before it was a book, when I was still just sort of beginning to work on this. And so maybe some of you were there then. It was the alumni weekend. I think it would have been maybe the fall of 2019. But now it's done, it's out, it's published. And I'll give you a little bit of a tour of it, and hopefully we'll have time for 10 or 15 minutes of questions at the end. So you can raise your hands among the participants or text me a question in the Zoom chat function if you have questions as we go. The book is called Autopsy of a Crime Lab. Its focus is on scientific evidence used in criminal cases. I'm teaching evidence now to our students, which is a fantastic class to teach. We don't spend too many days on expert evidence issues. There's so many other things to cover in an evidence class. I've certainly taught separate seminars on scientific evidence. It's a special skill to to put an expert on the stand or to cross-examine an expert. But what I appreciated more and more as I worked on this book is that particularly in criminal cases where we have organizations, we have entities, we have crime labs and CSI units of police departments, we have groups of people producing scientific evidence for courts, that we really need to think about this more from a regulatory perspective. Where does this evidence come from, and why does it so often go wrong? It's often not regulated like clinical labs are or other types of scientific enterprises are in this country. And it's that has led to terrible miscarriages of justice, closures of labs, all sorts of audits and scandals, and great expense, great human cost. And so I make the case in the book that we really need to rethink how forensic evidence works in this country, from the crime scene to the lab to the courtroom. Let's see, here we go. I wanted to also introduce this new Wilson Center for Science and Justice at Duke Law. We were launched as the Wilson Center last year during COVID, and so it was a virtual event like this one. Now that we're back in the building and teaching students, more students are getting to meet with us in person and engage with our projects. We have 50 plus research assistants, many undergrads who come from different scientific disciplines, as well as quite a few law students who are working on our projects. One of our three main areas of focus is accuracy in criminal cases, preventing wrongful convictions. And as many of you know, Duke has long led the way. We were a founding member of the Innocence Network with our wrongful convictions clinic. And here at the Wilson Center, we're more on the research side and studying and unpacking the causes of wrongful convictions. Later this fall, we'll release a big report on what has changed in the area of eyewitness memory science and what the implications are for courts and for police agencies. We also do a lot of work on forensic evidence, which is our topic for today. We do work on false confessions, on police interrogation practices. We also do work on other topics, such as pretrial and bail policy. I'm the court-appointed monitor of the O'Donnell consent decree, the first federal civil rights consent decree of its kind, involving misdemeanor bail reform in Harris County, Texas, which includes Houston. And we're doing work in other jurisdictions on pretrial policy and bail. We do a lot of work on sentencing disparities, sentencing patterns. There was a big announcement this week and a wonderful op-ed in the Boston Globe describing our work on plea bargaining, including documenting entire plea negotiation process in collaboration with several district attorneys' offices, including the Durham District Attorney's Office, the office of Satana DeBray, also a Duke Law alum. So we have a whole panoply of different projects, including with collaborators at the medical school focusing on behavioral health. These projects focused on pretrial and sentencing and other patterns and disparities in the criminal system. My focus today is on accuracy and specifically on the role that forensic evidence can play, both in preventing errors and in causing errors. At our center, we've also actually filed a number of amicus briefs in cases raising forensic science issues. At our launch event, where we announced the gift that made possible the Wilson Center for Science and Justice name from the Wilson Family Foundation. One of the people who joined us for that event was Joe Bryan, who has since been released from prison after many years in prison in Texas. We took the lead on a brief, along with some great lawyers at Proskauer, and amicus brief signed by leading scientists and legal scholars around the country, describing why the blood spatter evidence in his case was not evidence that would be deemed reliable in any way today. That subsequent scientific research has undercut all the conclusions that this very poorly trained, almost completely untrained officer described, saying that the blood spatter on this flashlight was blood and it had to have been held by the murderer at a particular angle at the crime scene. It actually wasn't tested, and so we're not even sure if it was blood, much less whether the spatter indicated anything in particular about having been at the crime scene. Our brief did not result in any particular ruling from the Texas courts. They dismissed his post-conviction petition, but then he was granted parole shortly afterwards. I mentioned that my monitoring work in Texas is another big Wilson Center project and personal project. But turning to forensics, my book begins the tour with just the first couple of pages of the book. I talk about the highest profile fingerprint error of all time in the case of Brandon Mayfield, an Oregon lawyer I'm very sympathetic to miscarriages visited upon lawyers named Brandon. This was the latent print at issue in the case. And you can see lots of things about what went wrong just by looking at this print. Many of us have given fingerprints for employment purposes or to get TSA pre-check. And when they tell you to give prints for some kind of employment or official ID type purpose, they tell you to roll your finger very carefully from right to left, and then you'd proceed to do that for each of your fingers. Sometimes they may tell you to do it over again if you didn't leave a good enough print. And you're trying very carefully to leave a good impression of the surface of the bottom of each of your 10 fingers. At a crime scene, there isn't that luxury to tell the person, can you just do that over? We really didn't get a very good print from you. And someone who commits an offense is not trying to leave any print, and they certainly aren't likely trying to leave a really good print. At this particular scene, there was only one print. It was not 10 fingers, it was one finger. And the print was left on a plastic bag, which is not a great surface. Plastic bags are crinkly. It's not an even surface. It's not the kind of thing that they would ever have you use if you were leaving a print for employment purposes. And what this highlights is that although there's a lot of information in fingerprints, and they are used for ID purposes, one challenge in the work of a crime lab, someone doing a comparison with a latent fingerprint, is that a crime scene print is highly imperfect and partial, smudged. We refer to latent prints when it's a print that can't be seen with the naked eye without something being done to it. So here there was dust used to make this print visible, and so the latent print became visible through dusting. But the dust itself, the powder, the smudges on the powder that you can see kind of crinkles from this plastic bag that the print was taken from. And there's a ton of information missing. I mean, you can tell that this is a fingerprint. You can tell some things about the pattern. The tips of our fingerprints have pattern, don't change after birth, absent scarring, or people who work a lot with their hands actually can have their prints worn off quite a bit. There's an overall shape to a fingerprint, and they talk about the shape being a whorl, if it's sort of a circular pattern, or an arch, or a loop. Here it looks like this might be an arch, not an overall circular pattern, but there are just lots of pieces that are missing here. And so a latent fingerprint examiner would be looking at this and trying to get a sense of what features can be observed and what might just be sort of noise, whether from smudges or the dusting and the like. And we all have some personal experience with the challenges of working with highly partial latent prints. Those of us who had smartphones in the fingerprint reader era know the frustration of trying to open your phone and it won't open because the tip of your finger is wet, or your finger isn't oriented the right way. Those little readers were small, and so they would only read maybe 1/10 or less of our fingertip. And so many people had the experience like, I know this is my thumb and I want to open my phone and it won't open, and this is annoying. Not a horrible inconvenience. It's not like going to jail for a crime you didn't commit, but it's the reason why the smartphone makers turn towards other things like biometrics or just simple passwords, because so many people had frustrations with partial fingerprints. Well, despite the common assumption that fingerprinting is up there with DNA, incredibly reliable fingerprints have so much information, in actuality, what is often being worked with in a criminal case is more like the phone reader that just won't open the phone because it's so partial. It's a print like this one, which has a ton of missing information. And in plenty of areas, it's really hard to tell. Is that a dot? Is that a break in one of the lines? Or is that just due to smudging? And actually, it's not a feature, it's just noise. It's really hard to tell signal from noise when you have really imperfect crime scene information like this. But that said, at this time, this is 2004, what a latent fingerprint examiner would say in court was, if they reached a conclusion, they would say that they had reached a decision which was certain, 100% certain. There was 0% error rate in their field. They did not make mistakes if they followed their methods properly. They would say that they had reached a decision which was an individualization or an identification, meaning that no other person in the world could have made the print in question. And how did they do this? What statistics were behind it? What probabilities allowed them to reach such a conclusion? There were none. It wasn't like DNA where there were random match probabilities where they actually knew how many people in the population would have some combination of features. They would eyeball the evidence, as they still do. And so they would look side by side at a crime scene print like this and a suspect's print and look back and forth. And if they saw enough similarities, they would say, okay, it's a hit, it's a match. Individualization, I cannot be wrong. How often were they correct? How often were they wrong? Well, they would say in court, we're never wrong, 0% error rate. Errors do not happen. That's how reliable this technique is. And yet it had never been tested. Errors had come to light, but the community had said, well, those must have been untrained people or people with some motive to get it wrong. A properly trained person never makes a mistake. The FBI in particular was very aggressive about these claims. When reliability started to be litigated after the 1994 decision in Daubert versus Merrill Dow Pharmaceuticals, and all of a sudden federal courts and then more states adopting the Daubert standard were conducting more of a reliability inquiry into expert evidence. And there weren't these peer-reviewed studies or research on how often does fingerprinting get it right or what supports, what is the statistical foundations of this discipline. And so basically the FBI went into court and said, well, we know how reliable this is. There's a 0% error rate. And judges, after some initial concerns and some hearing, largely towed the line and said, well, there may not be perfect studies, but we think this is reliable. After all, it's been used for over 100 years in our courts. The Mayfield case involving this print ended up severely calling into question the claims of the fingerprint community for so many years. So this was Mayfield's print, the print in question, and it shares a lot of similarities with that latent print. Has that same kind of arch-like shape. There's a lot more detail here, though. There's all kinds of rich detail in this print because this was a print that he gave for employment purposes, where he was rolling his finger carefully and trying to leave a good print, like a diligent person does when they're asked to provide that kind of workplace information. There is no way that he would have his print involved in a case like this one, absent a gigantic database. Many people have perceptions from CSI type shows that it must be computers that are doing this work, and a computer pulls up a hit, and it's not just a human sort of eyeballing things, but there must be great technology involved. Another reason the Mayfield case is really interesting is that technology instead played a role in a miscarriage of justice. It was technology that made it possible for someone halfway around the world to get falsely ID'd. So Brandon Mayfield is in Oregon. The case that he was implicated in initially was the Madrid subway bombings of 2004, a huge terror attack. There have been many mass terror attacks since then, but it shocked the world. These bombs go off in the Madrid subways during rush hour. Many people are killed, many people are injured. And there's every reason to think that that latent print that I showed you was absolutely connected to the culprit, because the plastic bag was a bag which had unexploded detonators. That bag with detonators was in a white van. Always suspicious to have a white van parked near a scene. The police converge on this van. It was parked close to the subway station. They find this plastic bag with detonators, and it seems pretty clear that whoever handled that bag was involved. But how does, Mayfield has never been to Spain. He lives in Oregon and in Portland. How in the world do you connect something to him? He would not be in any local list of people involved in terror activities. The only way you connect an innocent person halfway across the world is through a gigantic database with a search function whose job it is to pull up prints that look as close to what you're giving it as possible. So they feed in a marked up version of the latent print. And the job of the algorithm is to come up with prints like this one that look a lot like it. And so the more people's information you have, the bigger the database. There's a perception that, well, the bigger the biometric database is, the better. There's a greater chance the culprit will be in it. But there's also a much greater chance that lots of innocent people's prints that look a lot alike will be there. And there's a much greater danger of a coincidental hit to someone who's innocent. The more people's information, the bigger the database is. And there were some similarities between Mayfield's print and the print that had been found at the scene of the Madrid bombing. The examiners, mark it up, and they found 15 points of similarity. What was also really noteworthy about the case, up until this point, examiners had testified with great confidence in court, as these examiners did. They said that they were 100% certain that the print came from Mayfield, that it was his print, that it was an individualization. They used all that strong terminology that was common at the time, and is still common in a whole host of different forensic pattern sort of eyeballing type disciplines to this day. They were not, though, you couldn't say that, oh, well, these must have been inexperienced people who didn't know what they were doing. They didn't know the proper methods. These were all three FBI or former FBI examiners. One had 35 years of experience. The others had well over a decade and a half of experience. It's not typical to have three different people do a full examination, which is what happened here. And so you couldn't say that these were people who are untrained. I mean, this is the FBI, the top forensic agency in the country, a model for the world. It was a case that was taken very seriously. So they had extra people looking at these prints. And at the time they were like, 15 points, that's a lot. Like you don't see 15 points in common unless it's an ID. And so they went into court with this high level of confidence that, we found our person. Now, Mayfield goes into court and says, like, that's not my print. And then, he's a lawyer, his defense lawyer looks into this, hires a fingerprint expert on their own, which is not common in criminal cases for the defense to actually get their own expert. The defense lawyer looks at the markup that the FBI agents did and maybe wowed by the experience of these famous people at the FBI, says, I don't know, it looks like, I think it's Mayfield's print too. Now Mayfield, it seems like it's really sunk. And, there may have been reinforcing and circular reasoning and bias in several different directions here. The defense expert may have been wowed by the conclusions by these three FBI examiners. In retrospect, when an inquiry was done, it was quite clear that some of the examiners had some qualms and saw some differences in the prints, but they were influenced by each other. Like experienced colleague number 2, experienced colleague number 3 seems to think it's a match, so it must be a match. They also looked at the print side by side. And when you have a side-by-side process like that, you're going to tend to, in a circular fashion, focus on similarities and downplay differences. In the same way as when you see someone walking the same dog every day, people think that owners look like their dogs and vice versa. Or people see a couple walking together and you think that they look alike. Or there are those kind of kids puzzles where you have a scene of a playground and it's really hard at first to notice that you have to find the 10 differences. And in one playground scene, the kid is wearing shorts, and in the other playground scene, the kid is wearing long pants. And in one scene, it's a soccer ball, and the other scene, it's a basketball. It's hard to find those differences. And so a bunch of different biases may have been in play here. Another bias that may have been in play was, and Mayfield has talked about this quite a bit, is that he was Muslim. He was, practicing Muslim. He had converted. So was there an extra degree of suspicion because he was Muslim? There very well may have been. It seems quite likely, after all, there was no evidence he had ever been to Spain. And so the theory was that, well, he must be part of some secret terror cell, that he snuck there under some assumed identity. The fact that he was Muslim no doubt played a role and may have influenced these fingerprint examiners even more. And so there are a whole bunch of different ways this case illustrates bias. And that database, back to the database, his prints weren't the first candidate offered up by the list of candidates that this database pulled. These databases, the algorithms, if you ask them to pull the top 20 most similar prints or the top 50, they will pull whatever you ask. And it's human judgment that decides whether any one of them is a match or a hit or an ID or whatever terms they use. His were the fourth ones up. They weren't at the very top, but these examiners were nevertheless convinced that it was him. It later came to light when a re-examination was done that there were actual clear differences between his prints and the ones from the scene that these experienced examiners plus the defense expert had all ignored, which also highlights the sort of pressure to convict, the pressure to support law enforcement, all the cognitive biases that can play a role when you're really just having humans eyeball evidence to reach these firm conclusions without expressing any uncertainty, without any statistical models, without any real information about how reliable are these people when they reach these conclusions. If they could get it wrong in this case, where the world was watching and it was so high profile, how often do they get it wrong in low-level cases where the defense doesn't get an expert? Where the only reason they backed off here was actually the Spanish authorities got in touch with the FBI and said, we don't know what you're talking about with this lawyer from Oregon, because there's a an Algerian, a known Algerian terror cell participant who is in Madrid, and it's his prints. And we think it's the Algerian terrorist whose prints match, and not this guy from Oregon who we've never known about him even coming into our country. The FBI was so sure they even sent their examiners to Madrid to blow up these prints and show all the points and everything. We're sure it's a source identification, it's individualization, 100% certainty. And the Spanish authorities were like, what? No. The FBI apologized. They paid damages to Brandon Mayfield. They also made some important changes to the way they look at forensic evidence. But that said, outside of DNA, the forensics that are used that involve people just looking at evidence and comparing it still involve many of the same assumptions and are still presented in court as these unqualified type of hit type conclusions. And other forensics that are more automated, that involve more in the way of objective measurement, like assays used to chemical assays used to identify controlled substances, drugs. Lots of issues with how crime labs are run and the quality controls for that more objective presentation of forensic evidence as well. In part because of some of the same issues that we saw in Mayfield's case, where you have examiners that work for law enforcement, that are reporting to law enforcement, that may have other biasing information given to them, like Brandon Mayfield is a Muslim. And this is the FBI lab, not a lab that's backlogged with poor resources and poor training. My first book was called Convicting the Innocent. I focused on people who had been exonerated by DNA evidence. Mayfield was not exonerated by DNA evidence, right? He was cleared in the fingerprint, but I've initially focused on the role that DNA played in correcting hundreds of injustices at this point in this country. That said, when I dug into those trials, I saw how trial testimony by forensic examiners all around the country contributed to wrongful convictions. Working on this book, though, I realized that it's not just the trial testimony. It's not just when a case goes to trial and someone says it's a match, it's a hit, it's an individualization on the stand. There are also all the crime scene processes, the behind the scenes lab processes that all play a role in generating flawed forensic evidence. Another example of that is the Keith Harwood case. He was initially sentenced to death in Virginia, served over 30 years for a crime he did not commit. And this case really haunted me because I started looking at not just DNA exoneration cases, but I was starting to pull just random trial transcripts from Supreme Court archives in Virginia and Oklahoma, Texas, to see whether the problems I saw in these wrongful conviction cases existed in just random criminal trials, serious criminal trials, typically, serious felony trials from the 1980s. And in reading a few dozen trials that I basically pulled off the shelf in those states, I came across this Virginia case, and it stood out to me at the time because they had done these bite mark comparisons. And Keith Harwood was a sailor on a huge aircraft carrier. There were more than 1,000 sailors who were all suspected when there was a rape and murder in Newport News near where this aircraft carrier was being completed. And the victim survived, her husband did not. The victim could identify that it was someone wearing naval uniform who assaulted them, but couldn't identify the face or anything like that. Her thighs had been bitten during the sexual assault. Her husband was murdered. They then take a dental mold from hundreds and hundreds of sailors on this ship, including Keith Harwood, and it cleared him, and it cleared everyone else they looked at, and the crime went unsolved. Also illustrating kind of cognitive bias. A year goes by, this high-profile murder is unsolved. Keith Harwood gets into a domestic disturbance with his girlfriend, where my memory is that she was sort of choking him, and he bites her arm. It may have been self-defense, but it still wasn't a good interaction between either of them. But what happened was the police were like, oh, domestic disturbance, victim's arm was bitten, we have a biter. They then tell the dentist, well, let's look at his mold again. They look at his mold again, and they decide, oh, well, actually, now that we look at it again, it's a match. In court, they testify that it was a very, very, very likely match. A second dentist was more unequivocal. He said Keith Harwood made that bite. It was his teeth that bit the victim. Couldn't be more unequivocal than that. No cautionary language, no uncertainty. And by the way, there's uncertainty whenever you measure anything. I mean, I certainly know in our house, like I'm not good at using measuring tape, not good at measuring a couch. There's probably like a 6 to 8 inches of uncertainty type rule that we should have when Brandon is measuring furniture. Other people may be better trained and really good at measuring furniture. Even using a ruler, there is uncertainty. Anything that humans do, any instrument has calibration and uncertainty. But that's not how these dental experts testified in Harwood's case any more than that was how the fingerprint examiners testified in Brandon Mayfield's, material terror witness detention hearings. Years go by and he's eventually, I didn't realize at the time I came across his case at random that he was writing his first letters back then, 2009, 2008, to the Innocence Project in New York. Takes a few years, but they eventually get evidence that they can DNA test, and multiple pieces of evidence exclude him and include another sailor on that boat who also had a dental mold taken and who all these dentists had actually falsely excluded. He's become a forceful advocate for reform in forensics. Around that time, 2009, the National Academy of Sciences writes a detailed report talking about the needs of forensic science. Very little has changed since then. They said that we shouldn't have forensics as a law enforcement function. There's too much room for bias and for unscientific work. That apart from nuclear DNA testing, none of these techniques that claim to create a hit have actually reliably been shown to have a statistical foundation. We don't know how good they are. We don't know with what confidence they can make the claims that they make, and yet they're used in our courts every day. A subsequent report coming out of the White House Presidential Commission for Science and Technology, the PCAST, in 2016 says that for things like fingerprinting, we need to know whether there are studies that have been done that suggest how reliable the work is. What are the statistics? How often do fingerprint examiners correctly link evidence, or how often do they incorrectly link evidence? They found that there, in the fingerprint area, there had only been 2 studies done, and one was much smaller than the other study. 2 studies, is that really enough to use this evidence in court to convict people of crimes? Not clear to me that it is, but they sort of said, well, that's sort of the bare minimum you'd want before using something in any way. And they found, if you look at these studies, the error rates have a wide range and could be as high as 1 in 18. And they say, like, jurors need to hear this. Even if you are going to let this evidence in court, you can't let it come in unqualified. People need to hear how reliable this stuff is. They also note, when you have evidence like this, which is not just about using a ruler where there might be some uncertainty in measurement, but where the process is in someone's head. Like if you ask the dentists in Harwood's case, or the fingerprint examiners in Brandon Mayfield's case, well, what are you measuring? How many points do you need to find? They would say, well, it's in my head. It's based on my experience and training. I look at this stuff and I use my own judgment. If I see sufficient indicia of similarity, then I conclude that it's an identification. Well, how good are you at doing that? It really depends on how good that person's training, experience, and judgment are. And it could be that someone very inexperienced is terrible and makes mistakes most of the time. It could be that someone who's very experienced is quite accurate. We don't know unless we measure the person. We need to know how good a particular expert is. And unlike in other fields, these people are qualified as experts without any objective information, testing them to find out how good they are. A judge would never let a person be a courtroom translator who hadn't been proficiency tested. You wouldn't say, oh, you say that you're proficient at translating between Russian and English. Well, if you say so, you can translate between Russian and English in my courtroom. Great. We wouldn't accept their say so. We would test them and we would see how good are you in real time at correctly saying words in Russian and repeating them in English and vice versa. But with forensic experts, we've kind of taken their say so. Oh, you say that you're experienced and have looked at fingerprints for many years? Oh, you must be an expert. Accredited labs do have to have annual proficiency testing, but they're widely understood to be basically a joke. They don't have to be taken individually. They can be taken in groups. These tests are understood as being simple and elementary and not designed to be challenging. People can take unlimited time to take the test, even if they do take it individually, which they don't have to. They can have others check their work and go over it. So it's kind of remarkable that anyone fails tests that easy. It would be wonderful for our students if the bar exam was that easy and you could take it in groups and have unlimited time. And the Bar Association said, we've designed this test to be extremely easy. That's what happens with crime labs. There are other types of mistakes that happen. There's a wonderful movie featuring Hilary Swank playing the role of Betty Ann Waters, who is sitting on top of the shoulders of her brother, Kenny Waters. She personally put herself, and she did not have a lot of money, like she was waitressing and the like. She put herself through college and law school so that she could become a lawyer and exonerate her brother, who she believed was innocent. DNA testing proved his innocence. She did that. She went to law school and exonerated her brother, who who then tragically died a couple of years afterwards. But all along, she was wondering, okay, I want to get the DNA testing, but they didn't have DNA testing at the time of his trial. They did have fingerprints. And there was a police report that mentioned fingerprints. Where are those prints? And years later, when they filed the civil rights case, they found that fingerprints had cleared him at the time and were never disclosed at trial. We see that time and time again, that there is evidence pointing to someone else, or evidence that in fact clears someone that isn't disclosed or isn't introduced. And that's a different type of error. It's not a false hit, it's a false negative. It could be a false exclusion or a failure to exclude someone who is innocent at the time of trial. There are also inconclusive errors where examiners look at a smudged print and say, I can't do anything with that, when in fact they could have used it to connect to a guilty person or to clear an innocent person. And in real life, there are a lot of cases where examiners decide that there's just not enough there and they don't look at the evidence carefully, they don't proceed. As part of my work with psychologists, we've done a whole series of studies. At this point, we've tested tens of thousands of people serving as mock jurors in experiments. And in these experiments, we pretend that there's a world where jurors actually hear information about the reliability of forensics, which they don't really, for the most part, in court. But if we tell jurors about error rates, if we say, well, by the way, there have been 2 black box studies done in fingerprinting, these are the error rates, they're much less likely to convict. They don't throw out the evidence, but they take it into account. And we found time and time again that if you give lay people the information they need, we don't have a problem in this country of people uncritically accepting science. People have very strong views that forensics is powerful, in part because of media depictions, but also we've been hearing long before there were CSI shows, we've been hearing that you can make a fingerprint match for decades. You know, fingerprinting is often like a visual metaphor for human individuality. People assume that fingerprinting is as reliable as DNA. That's what they say when we survey people, and most people I talk to assume that. But they don't assume that if you explain to them how it works and that this is just like people eyeballing patterns and we don't know how often they're right, and this is what we've learned from studies about error rates, people can take that into account. Jurors are very much focused on what is the strength of this evidence. If we give them the information they need to do their jobs, they can do their jobs. We've also shown that if you give jurors information about how proficient an expert is, if they are actually given, if these people actually were given demanding tests, say there's 100 test items and the person gets 80 out of 100, jurors take that into account. They want to know how good an expert is. People don't have uncritical acceptance of scientific experts in this country. People want to know how good the expert is, and we should be telling them. Instead, what they often have is this. The prints were identical. It was Stephen Cowan's. He was exonerated by DNA. The fingerprint expert was wrong in his case. And we see that time and time again, that at trials, in testimony, in the reports that lawyers see when they decide whether to plead a case out, they're never given any of this information about what are the limitations of the method, what's the uncertainty. The PCAST report said we shouldn't even be talking about identifications. We should be talking about a proposed identification with information about, well, what's the uncertainty? What are the limits of this discipline? The Department of Justice has made some changes in response to these criticisms. They've said, like in fingerprinting, you shouldn't be claiming individualize. You shouldn't say 100% certainty anymore. You shouldn't claim infallibility or a 0 error rate. All that is good. But they're not actually saying, okay, DOJ, well, what are you going to recommend that be said to actually explain how reliable the technique is? What are the limitations? How good is this expert? How proficient is that person? They still aren't recommending that these people actually provide the jury with the information that they need. Those recommendations also just deal with the courtroom. They don't deal with the kind of bias that can occur and that can distort what an examiner does before anything reaches a trial. This is Dr. E.T.L. Juror. He did a wonderful experiment where he gave 5 examiners fingerprints and said, these are the prints from the Brandon Mayfield case, like the most famous latent fingerprint in history, the one I began my talk with. They looked at those prints and said, inconclusive or doesn't match. Well, in fact, he had played a nasty little trick on these 5 quite experienced fingerprint examiners. He had actually given them prints from regular cases that they had worked on the year before and that they had concluded came from the same source. But with this aggressive biasing information, this is the Brandon Mayfield case, they changed their minds. Study after study has been done in lots of different forensic disciplines, where if you give milder biasing information, information about which side is asking you to look at the evidence, the prosecution versus the defense, that examiners will predictably change their minds if they are given biasing information, particularly if what they are doing is less an objective measurement and involves vaguer standards and more of their own judgment. And so for these disciplines like fingerprinting, for firearms comparisons, certainly for bite mark comparisons, where there's a lot of sort of in your head black box, you're eyeballing stuff and reaching a judgment, much easier to bias a person, much easier to alter the results outright. And the kind of firewalls that you would want to prevent that kind of bias often don't exist when the vast majority of the crime labs in this country are part of law enforcement. They are police labs or they are part of state law enforcement. We have very, very few independent labs. Nor is independence necessarily enough if you don't have good quality controls in place. Now, one source of quality control could be judges. Judge Rakoff here has been a critic of unrestrained and unqualified use of forensics, but very few judges have been. And when we've done studies of Daubert rulings in criminal cases around the country, one study was one that Chris Fabricant and I did. We digested a couple decades, basically all of the state law decisions on appeal after states adopted the modern Rule 702 reflecting Daubert. It was almost vanishingly rare to find decisions that actually say words about the concept of reliability regarding experts in criminal cases. And when they did say something about reliability, apart from just quoting the rule, they almost always admitted the evidence. In recent years, there are some more cases that actually dig into scientific research and say some things about reliability, but very, very rare to find courts even engaging with the question. And what happens? Well, we've had lab after lab collapse outright, or have audits, have cases reopened. Right now, in Massachusetts, 40,000 plus cases, it may ultimately be 100,000 cases are being reopened. Often the response initially is that sort of like when the FBI was asked about error rates in fingerprinting. Well, there have been mistakes, but those are incompetent, individual bad apple examiners. And then the best of the best make this mistake in the Brandon Mayfield case. Well, initially it was two drug analysts doing, a largely automated, chemical assay type process, testing drugs in drug labs. The two main drug labs in Massachusetts each had a chemist that was using the drugs rather than testing it. And they talk about doing drugs colloquially in that field of work. They usually don't mean it literally, but these examiners were doing drugs. It's tedious work, and they were using a lot of the drugs in the lab. But when you have a lab that has people not testing the evidence at all, faking their work, and instead using the drugs, it's not just about them. Like there's a serious breakdown in quality control if something that bad is going on for years undetected. And it later became clear that the equipment was contaminated, like none of the work product coming out of those labs was salvageable. And so at great expense, tens of millions of dollars have already been spent. All these cases have to be reopened. But at this point, people have pleaded guilty, they've served time in prison. They can never really be compensated for what they've gone through. And we'll never get to the bottom of whether that evidence was good evidence or bad. This is happening around the country. It's happened in every state. There have been big scandals in North Carolina. The DC lab, it got this fancy new building. They had an independent scientific oversight board, but the board met infrequently. It was the same people working at the lab that had formerly worked at a police lab, and there was no auditing or oversight of casework involving blind testing or the kind of quality controls like spot checking, site visits, independent oversight like you have at any hospital or any scientific laboratory. That just doesn't exist really in this country, except maybe in one place. And so the entire lab is shuttered right now. There was a result in a firearms case that was false, and the lab tried to sort of cover it up by saying that we've changed our minds. We think the evidence is inconclusive, so we can't be right or wrong. We're just not, it doesn't cut either way. We're just not sure anymore. That false report was made to their accrediting body. The lab is now shuttered, for the indefinite future. But we have no idea how many old firearms cases by those same examiners that so easily changed their results when they were subject to criticism. How many other cases are affected? How many defendants may have been convicted based on faulty firearms evidence? Do they even have records of how many firearms cases and in what cases they've done work? And how many people have been convicted based on firearms evidence? The whole firearms unit's work is in question. Can we reopen those cases? At any hospital, if we found out tomorrow that there was an MRI machine at the Duke Hospital that was malfunctioning for 3 hours, they could generate a list of every case that was affected and bring in those patients to get a new MRI. They would do that quickly. At a crime lab? No. They may not have the most basic record keeping needed to identify what cases may have been affected by errors. And so their firearms unit is now, we don't know how many cases may have been flawed. There were already warning signs. There was a firearms examiner who failed one of these super easy proficiency tests a few years back, and the lab said, oh, that was just an isolated issue. Um, there have now been altered findings, judicial inquiries, and again, it may take years. One problem, though, is that, well, what did their reports look like? This is a different report by a similarly accredited lab, the Philadelphia Police Department lab. That's an entire report, basically. The back will have some signatures on it, but it just says the firearms. It was identified as having been fired by object P1. That's it. Nothing about the limitations, nothing documenting the work, showing what features were relied on, nothing about the proficiency of the expert. It's just really a one-line, I made a call type report. So what is a lawyer supposed to do to evaluate this? What did the person do? How long did they work on it? What visual features did they rely on? What are the limitations of the technique? None of that information is in this type of standard reporting, which is totally conclusory. We've done work looking at firearms and asking mock jurors how they evaluate such evidence. We found that a lot of the differences in terminology that courts have, concerned courts have imposed, saying, well, maybe what we should call it a reasonable ballistic certainty, given what we know about the unreliability, potential unreliability of this technique. None of that matters. Once they hear it's a firearm hit, they believe it's a firearm hit. Really cautious language where the firearms examiner says they cannot exclude the evidence, that has some impact. I'm going to skip over a couple of things. I'll note that our collaborators at the Houston Forensic Science Center are doing something very different. 5 out of 100 cases that everyone works throughout the lab on are fake cases designed to test the person, where the quality unit knows the correct answer. They can catch errors in cases that aren't real, address problems with the quality of the work in the entire lab. And it's part of a culture of catching errors before they contribute to something serious. The prior police lab in Houston was shut down because of rampant errors, including in wrongful conviction cases where the city paid tens of millions of dollars in damages. Since the idea is we don't want that to happen again. We know how to do quality control in other disciplines. We know how to do it in clinical laboratories. We should be doing it in crime laboratories. They're doing it voluntarily. There is no regulation to require this, and there needs to be national regulation. That's what the National Academy of Sciences called for back in 2009, and it just hasn't happened. I'm running out of time, and I want to take questions. There are all sorts of issues that new technology introduces, which is very much in line with the problems that we have with black box human experts who say, I've looked in my head and I decided to match. Well, we can have black box algorithms designed by humans that don't explain their work any more than the human expert does. And they say, we've looked at the photo and we found a match. And courts for too long have been willing to allow forensics to be presented unexplained in court. In Willie Allen Lynch's case, he says, I'm not the guy in this photo. What is this facial recognition software? What other images did it generate in its list of candidates? And how does it work? What's the algorithm? The Florida court so far have said, oh, you don't get to see that. That's not a due process right. And how can that not be? How do you confront an expert if you don't know what they did and how their work proceeded? The expert themselves may not understand the algorithm. How can that person be an expert? The same problem with new technology that we have, that we've had for decades with old technology. And we are all in these databases. In North Carolina, if you have a driver's license, they tell you not to smile. Our faces are in the federal face database. If you've been to an airport, your picture has been taken, you are in the face database. But the FBI hasn't tested that database for false positives, false negatives. We don't know how accurate or inaccurate it is. Their defense has been sort of like the DC lab with their inconclusive. They have said, well, we use this to generate leads. We don't know whether it's being used correctly or incorrectly. That's not our job. We generate facial leads and police departments can do what they will with it. That's why we don't need to error test this algorithm or share more information about it. Same kind of problem that we've had with forensics for years, where untested evidence is being used in criminal cases. So I just want to end with a short video clip from Keith Harwood, whose story I told in the beginning of the talk.
And I spent more than half my life. I went in when I was 26. I got out a year and 2 days ago, and I was 60. I still have 6 more years before I break even behind what somebody said was true and was not true, and the courts allowed it. There should be some kind of regulation. There should be some way that experts have to meet a bar, a very high bar, because you end up ruining people's lives.
So I'll stop there. Keith Harwood gave a wonderful talk here at Duke pre-pandemic to our students, and I can share a link. It was a wonderful presentation that he gave about that story in his case. But he says it best. There should be regulation. There should be a bar. that's where I come out at the end of my book. And I'd love to hear your questions and thoughts. I'll stop the screen sharing and look at the chat, and would love to hear from you all. Thank you.
Thank you so much, Professor Garrett. We will send those links around following today's conversation. So we will make sure everybody has those resources. But we do have a few moments. If you have any questions that you would like to share with Professor Garrett, you are welcome to take yourself off mute and ask your question, or if you'd rather put them in the chat, you can do that at the bottom of your screen.
I can call on people too, if you'd like. I don't know if cold calling is allowed for alums.
Looks like we have one in the chat from
Yes.
Reed.
So are there organizations pushing for the type of change that my book promotes? Actually, we just got a really interesting and hopefully impactful grant at the Wilson Center with the idea that actually crime labs and forensics reform has often been a focus of criminal defense groups like the NACDL, the American Bar Association has made a statement that forensics should be validated. The defense should have access to lab reports. Like the American Bar Association has issued good statements on this issue. Innocence projects have been involved, but it's often been sort of a defense focus and a law focus. A funder sort of came to me after I wrote this book and said, civil rights groups should care about this too. We've been talking so much about police reform in this country and bias and racial bias in policing. We don't want forensic work to be biased by police. We want it to be independent. This should be on the agenda for police reformers to have this work. If you want to solve serious cases, we actually shouldn't be funding police. We should be funding independent crime labs to do this in a scientific way. And so we're developing toolkits for organizers to kind of lay out these issues as part of a police reform agenda. We're not advocates, we're not activists, but we can walk through these issues and walk through possible regulations and lawmaking strategies in the same way that there have been efforts to create more independent investigations of police shootings and rules. Some cities have said we're not going to do facial recognition anymore in this town, or we want to regulate how body cams are used to make sure that there's access on both sides of the bar to the body cam evidence. We could also have legislation saying crime labs should be independent. They should have separate funding. They should have scientific oversight. So we don't have disasters like happened in Houston, or like even happened in Washington, D.C., where they did try to make the lab independent, but they didn't do the oversight part when they made it independent. And so we are working on that ourselves here at Duke. So another great question is who would regulate accreditations? And there's voluntary accreditation of labs, but it doesn't look like what we have with clinical labs, where, if you get a strep test or a cancer screen, those labs have rigorous proficiency testing. If someone fails demanding tests, they have to be taken off the job and retrained. There are site visits. There are all these detailed regulations surrounding quality controls and quality culture, quality management at clinical labs. None of that exists for crime labs. There is an easier federal hook because clinical labs are all, there's Medicaid funding, there's federal funding flowing in through the healthcare system. It'd be pretty hard for a clinical lab not to be dependent on federal dollars. So it's easier for there to be national regulation in that context. But the National Academy of Sciences proposed that there just be a federal regulatory agency that supervises forensics, the National Institute of Forensic Science, that would issue the standards and accredit labs. And it just hasn't happened. It hasn't been a priority in Congress. And so we don't have that. We could have state level regulation. There is one state that has a forensic science commission that has some oversight authority to do some kind of quality control and oversight. That's in Texas. They've done some things. They have a very small staff. It doesn't look like a federal administrative agency where there's a lot of ability to do site visits and inspections like OSHA or any of the other federal agencies. It just doesn't exist in forensics. There's some glimmers, but not much. A great question on probabilistic genotyping. A really good example of a new approach towards familial searches in DNA is what Maryland did, where they convened an entire commission to think about the ethical consequences, the privacy issues, the family privacy issues in doing familial DNA typing, that it shouldn't just be agencies running around with a new approach towards DNA without public oversight and ground rules. I think we need the same thing for probabilistic genotyping to both be sure that the science that's being used is accurate and also think about the ethical implications and the legal implications before just sort of letting agencies run wild with a new use of technology. So I think the Maryland approach towards bringing together different stakeholders and deliberating about it and then regulating it is the right way to go. But we typically haven't had that done. There's another great question about whether raising the bar to more carefully look at the reliability of expert evidence, will that hurt the defense when it's harder for the defense to get experts? And I would also add that there's often been much more judicial skepticism of defense experts, that when you see careful inquiry into reliability, it's often because it's a defense expert. And that defense, it's harder for the defense to even get funding as an indigent defendant to hire an expert. And even when they do, you have judges asking all sorts of questions about the reliability of that expert when they don't ask questions when it's a prosecution expert. And, the National Academy of Sciences, lots of independent groups have remarked on this unbalanced playing field in the area of expert evidence in criminal cases. And it's a real problem, and it's a really good question. And it's not clear what the answer is, particularly because there just isn't a practice in most states of giving the defense equal access to experts. In the military system, both sides have equal access to experts, down to the funding, down to the number of hours they have to consult with an expert. And that's a much more even playing field. In federal cases, there's much better access to experts than in states, not as good as in the military system where there's complete equal access, equal resources. But in most localities, it's really hard if you're a defendant to get an expert. We found in our studies of mock jurors that it's really impactful to have a defense expert, even just to comment on the discipline and its limitations. Someone who says, I didn't look at these prints, but let me tell you about each of the steps in the fingerprint comparison process. Let me tell you about the assumptions that are built into that method and the subjectivity inherent in it. And this is what we know from error rate studies, that it's not perfect, that there are error rates, and this is what they are. Just hearing that gives a different picture of what the method is. And has a big impact on outcomes, even if the expert doesn't come to a different conclusion about these prints or these shell casings or whatever. But judges haven't appreciated that a methods only expert is valuable. Here and there, we've started to see in recent years, statisticians or social scientists come into court and say, I don't look at hair, I don't look at fingerprints, I don't look at firearms, but let me tell you about statistics. Let me tell you about social scientific methods. And all the questions that we don't know about whether this method has been validated. Those experts have had a big impact in individual cases. But in the past, you never heard from hard scientists in criminal cases. So one last great question. I know we're running out of time. Great question about references for trial attorneys to use to cross-examine expert witnesses. The NACDL has some really good materials. We have a boot camp course here at Duke Law, which is all about how you cross-examine an expert in a criminal case. And it's open to practicing attorneys. We usually allow a handful of attorneys to take the class for a CLE credit, and then a dozen or so law students. So for some of the most challenging crosses, the lawyer takes the lead, but assisted by the law students, and then the law students do the simpler directs and simpler chapters of the cross. But we spend an entire day preparing the witness and interviewing the witness, and an entire day of cross-examination of this mock expert witness who actually does have a forensic science background. So it's a forensic science cross-examination boot camp that we do. We've shared our materials with other schools if they want to do something similar, and we're talking to some of the both prosecution and defense criminal trial colleges about using similar materials. I tend to think that reading mock crosses and the like is fine, but experiential education is much better to actually have done it and have some memory for having used those skills. And actually, it's just very different when you actually have a witness that you have to cross-examine. And so we're giving our students that experience, and some lawyers as well, and we're trying to make our materials available to others so that they do boot camps like this. And it's not like our clinics are fantastic here at Duke Law. but we also can do simulations to give our students experience as well. So I know our time is up, and it was
Yes.
such a treat to have a chance to share with you all. And you have my contact information. Please get in touch if you have other questions or want to hear more.
Thank you so much, Professor Garrett, and thank you everyone for joining us today. We are right at 2 o'clock Eastern time, so we are going to wrap up here. If we did not have a chance to get to your question, please feel free to email them to our office and we will pass it along to Professor Garrett. As I mentioned, we will be sharing a copy of today's recording in the coming weeks, and we will also send along those additional references that Professor Garrett shared at the end of the presentation. So I will go ahead and end us here today, but thank you again for joining us, and hope you can join us for another program in the future soon.